to Litigation Help. My name is Heather Huilitun, and today we're going to talk about what to do when you've been served court papers. Joining me here are regular guests Laura Tarcea and Eva DiGiammarino, both from Family Mediation Group. Hi, guys.
Hi.
Hi.
There's been a question that I've been wanting to ask you guys for a while now, and this is kind of almost like based on even my own personal experience, because in my own personal lawsuit, and this is now more than 10 years ago, can you believe, I was a defendant. And so I remember that moment when I've been served court papers, and I'm like, what is this? What's going on? So I was wondering if you guys could give us some tips as to how to handle that. I mean, I felt so scared and
hmm
overwhelmed, and I just didn't know what to do. So, what should
hmm
the person do when they've been served court papers?
Sure. So we can certainly speak to it, on the family law side.
Mhm.
And I remember in my litigation days, which were a long time ago,
Yeah,
I always say, despite how youthful I look,
Even though she looks
um,
very young,
yeah,
yes.
over 10 years ago, when I used to represent people in court,
yeah,
I used to say, getting served, especially when you're not expecting it, is such an emotional roller coaster.
yeah.
And when I was working with families, I would encourage my clients to say, can we give the other person a heads up that they're going to be served? Because oftentimes people are served at work and or they're served in public,
Right.
right? Which adds a layer of kind of humiliation and being caught off guard and then, kind of that nervousness. So, I'm glad you're doing a video or a couple of videos about, being served because it can be a stressful point in a conflict. It can increase conflict very quickly. And perhaps in this video, we can provide your viewers with information about how you're not stuck in the court process. Just because you're served, it doesn't mean that that has to be a kickoff to a huge conflict that is going to make your life miserable and expensive and time consuming, even though it can feel like that in the moment.
Oh, I definitely can relate to that. I remember being served the papers, and then my next thought is how am I going to handle a trial?
Right.
A trial. Everyone, nobody wants a trial, right? It's
Right.
a horrible, horrible experience. So if you could maybe explain that very moment when you receive the court papers, what is the first thing you should do?
So everyone else can roll their eyes, but I'm always going to say that the first thing you're going to do is actually talk to some trusted friends and neighbors to get recommendations for lawyers that they've personally used and
Mm.
that they recommend. You are going to need a lawyer who practices that area of law and can speak to your requirements in a litigation perspective, even if you don't want to stay in the court process and you have intentions of, asking the other side to try to resolve things out of court, which is always recommended. You do want to go to a lawyer immediately, very quickly, right? Once you're served, to make sure because there are timelines that the court expects you to respond, and you don't want to miss those timelines because there can be financial penalties for doing so, right? So you can, if, for example, if you're served on the family law side, you would want to talk to a family lawyer who does have a litigation background. And you can tell them right off the bat, listen, my intention is I want to get out of this process. I want to offer, to maybe negotiate out of court or go to mediation or go to arbitration. But sometimes that conversation can be ongoing. It can take a long time. And so the lawyer is going to want to make sure that they're still preserving your rights and ensuring that you don't get any financial penalties while, they may reach out to the other side and suggest, an alternative.
Oh, wow, because there are lots of rules on the litigation,
hmm
right? So you don't have much choice but to get a lawyer. And I just want to clarify the term litigator. I remember I didn't even know that term when I
Right.
the first. So can you explain maybe what is a litigator?
Sure. So not every lawyer goes to court and takes clients to for court cases.
Mhm.
So for example, that's my practice is limited to being a mediator and representing families or a client in negotiations. If someone came to me and they said I was served, I would tell them that I would not provide them legal advice, even though I technically could. It's not my field of practice anymore. So you would have to, when you're looking up a family lawyer, you would have to make sure, and usually on their website, it indicates whether that's part of their scope of work, whether they are able to represent you in court or they're willing to take your case because it has a litigation background. Some lawyers will say that um, their scope of work, the services they practice, are limited to, like me, mediation, negotiation, collaborative files, which we can talk about. So some lawyers are limited. And so what we would say is, look for a lawyer who says that they practice in court.
So for the viewers, I'm going to put some links in the description box for some of the ways you can look up lawyer referrals, like the Law
Yep.
Society website or the NSRP website. Now, you mentioned, well, of course, the best thing is if you could negotiate and settle, of course, so that nobody has to go to court. But can you tell me a little bit more about, so maybe Laura, can you tell us a little bit more about some of these out of court options that people have?
Sure. I think the first step is when you get served is what Eva had mentioned is to have the advice of a lawyer who litigates because of what you've also mentioned, Heather, there are a lot of rules and there are rules and steps and technical steps. So one of the things that you shouldn't do or one shouldn't do is sit on it. And we've had clients in the past who said, I'm just going to ignore this and thinking that it's going to go away. It's not going to go away, and you can find yourself in hot waters and with penalties that would be set against you. So because once it is in court and once it follows certain procedure, you should have someone who understands those procedures and can advise you on the steps, whether you answer and whether your answer to within the deadlines that are in front of you are to invite someone in a collaborative space or to invite someone outside of the court in mediation or in mediation arbitration. That still requires you to answer. That still requires you to have the legal advice from a litigator and answer, not just send an email or ignore it and hope that somebody is going to drop the court case. So it doesn't work. It doesn't work quite that way. So follow the steps for the answer, and then you can invite someone to proceed to a more collaborative process and keep this out of court, such as mediation or collaborative law.
What do you mean by collaborative law? Is there is that a thing? Like, is that something special?
So yes, it is a thing, and sometimes it is a little bit challenging to grasp, but because the collaborative lawyers are lawyers who they have additional training in collaborative practice. So generally when you sign a retainer for legal advice or legal representation with a lawyer, they sign with you and they'll follow you throughout your case wherever it goes. Usually, even if it goes into court. However, with a collaborative lawyer, you would sign a retainer where you stay out of court. The lawyer will not proceed to court. So if negotiation, they will help you, they will represent you in negotiation, collaborative negotiations, hopefully with another collaborative lawyer. And the clients sign a retainer where both lawyers are not going to go to court and they will only represent you in negotiation. If the matter, and that's the downside of this, if the matter doesn't settle, then they would have to start from scratch with another lawyer who litigates if the matter has to go to court. So it's a little bit of a double-edged sword. In a way, it's a very it's a great construct in my view that you have the support of legal advice and the assistance which you need to know your rights and your entitlements. It's just the downside is, if this collapses and it doesn't get to a settlement, then you have to start with a new lawyer, which could be time and costly.
So let's say I've been served and I did a response well within the deadline, and now I want to
30 days.
consider these other court options. Am I allowed to just approach the other side and say, hey, why don't we just talk this out and settle? Can I contact my opposing side directly?
So there's no prohibition on talking to the other person, especially if they're your co-parent, right? And you have children and you may say, hey, like, so you certainly can talk to them, but for substantive legal conversations, generally, if the other person has a lawyer, then it's expected that you would discuss substantive elements with their lawyer and not, lawyers don't generally like being cut out of the conversation, right? But it doesn't mean that it's off the table. So what I would say is informally, of course, especially if it's your co-parent and you want to say, hey, like, I want to resolve things out of court. There's nothing wrong with that. But formally, in an ideal world, it would go lawyer to lawyer, right? And then that also, too, it looks good. It always looks good when someone formally requests to stay out of the court process. Judges like that. Judges like to see parties attempt at keeping their cases out of court because it shows that the parties are at least open to the fact that, the court system should be reserved for people who just really need it. And you should exhaust all other options before going to court. And so when one person puts formally in writing a request from their lawyer to the other lawyer that you pause a court process and go to mediation, for example, it's actually looks bad for the other party to say no. Right? Because the court does expect them to take every opportunity to try to resolve things out of court.
So you mentioned the word arbitration. Can you do a quick sort of explanation of what's the difference between a mediation versus an arbitration?
Yes, so arbitration, a decision would be made at the end, an award, which is called an award. So there is a mediation arbitration hybrid process where families can engage. And if there are, for example, 2 out of 3 issues not resolved, then they go directly to the arbitration piece, and the arbitrator will make a decision for the parties. It is much faster. It's almost like a private trial. It's evidence-based. It does feel actually like a trial because it follows the black letter of the law. It's not as flexible and practical as it is in the mediation phase, where you can be a little bit more creative with the options that you generate. The arbitration has to follow certain rules. And an award at the end will be provided on behalf of the parties, and that is pretty much akin to a court order. That could be appealed as well if there is an issue, a technical issue. Usually, it's hard to appeal it, but you can appeal it just like any other court order.
Right. So let me see if I understand. So if you, let's say you guys get together and you have mediation. It was great up to a certain point. You managed to settle a whole bunch of issues. Let's say you have, say, 3 issues left. So these outstanding issues, I suppose they could eventually go to the court, right? Go and have a trial. But the advantage of going to arbitration is that it's faster because you can hire your own judge, so to speak. Is that right?
Yes. That is one of the advantages for sure. It is the fact is technically it should be a little bit less costly as well, because a trial can get to hundreds of thousands of dollars if somebody gets to a trial in legal fees. So yes, you will need your lawyer present. You're not required, but you should have your lawyer present, especially during the arbitration, because it is pretty rule driven process. So you don't want to mess up on technical small steps that could go against you. But it is less costly, less time, and you have some finality, especially if you're in a family law case where you really do need to finalize things quicker, generally, because you need to start raising children or having a co-parenting relationship. There are many other things that you need to start tending to, especially if there are children involved. Getting to a trial can really delay that. So you're looking at 1 to 2, 3 years if you're heading to a trial versus a few weeks if you're heading to arbitration. So that's quite the difference in time and cost.
So I suppose if you have some issues about, say, support, and you can't wait 2 to 3 years, I suppose you could maybe hire a litigator to kind of help you out in that respect. Maybe they can do a motion or something to get you some interim orders. I'm just guessing here. Is that right? Or is that what you would do?
So it depends where you're at. I mean, if we're talking about the scenario where a court process has started, the
Yeah.
parties say, okay, you know what, let's pause it, go to mediation, see what issues we can resolve.
Right.
Because, we tell families all the time, let mediation surprise you, right? People often think, my ex is never going to agree to X, Y, and Z. Why should I go to mediation? Let's just stay in court. But what we tell families is, you're not the first family to disagree on things. Mediation is meant for you, right? We have the tools to help you. So let's say of 5 legal issues, you resolve 3,
Right.
right? So we have 2 legal issues remaining. Then the parties can just restart the legal process, right? And it starts from getting the paperwork involved. And then in family law, it may be a misconception, but you don't go straight to trial. There are processes in between, right? Which I know, Heather, you have videos on,
Yeah.
speaking to them, but there's essentially a case conference where a judge again is going to try to get the family to negotiate, right? And try to help the families settle at that stage. And then if the case conference, nothing gets settled, then really the lawyers are preparing for trial, but there's still meetings and motions and other legal processes in between that will try to get the families to settle or resolve things before, because like Laura mentioned, the trial step can be very cost prohibitive.
But I was just wondering about the interim order, because I hear people telling me that, I have an interim order that's only going to be effective until the trial. Now, how
So
do
yeah,
we get
some families do need one, and yes, that would be a motion that would happen typically after the case conference, unless someone has a legal basis, like an urgent issue where it has to happen immediately. But yes, an interim order just usually outlines what's happening with either living arrangements or support, child support, spousal support, until the decisions are finalized. But you don't need to go to court for an interim decision. You could actually, or an interim court order. We have families who come up with interim arrangements. So what's going to happen from now until we resolve this issue in mediation or with lawyers all the time? It's
Oh,
not
that's good
something
to
that
know.
just has to happen in court.
Oh, no, that is good to know. I think I misunderstood. Well, it's just where I come from is like everything has to go through court. So you could just like civilly get together and have an interim arrangement, right?
Yes.
Yeah.
Yeah.
Okay. Sounds good. I think that's pretty much my question.
I think one of the key takeaways would definitely have to be that, most families, given our legal system right now, outside of the great work that you're doing, believes, and our society believes that the first step is to go to court. The first step, when you start a process such as a separation or whatever, you have to serve the other person and you have to go through court. And then once you serve that paper onto your, let's say, co-parent, if we're talking into a family law space, then the other is pretty much frozen, thinking that, oh, I have to now get a lawyer. And then what I have an issue with, I'm sorry, and you can decide what you do, but is that once you have to hire a litigator, then chances are that you are stuck in the process of the heavy machinery of the court legal system when you don't have to. So when you as the individual, as the client, needs to know that that's not your only path. So the client actually has to know what to tell their lawyer.
So talk about that, Laura. Add an extra layer
way
about
around. But that's what I'm trying to say, that it's a tough nugget, because yes, you have to get a litigator when you are served.
Right.
But then what is the litigator going to tell you? And what path is the litigator going to take you on, unless you are informed, just like here.
So maybe Heather can ask Laura, why is it so important to first speak with a litigator that you trust and that has been referred to you? Because I think that's what Laura's getting at, right? Is that you could have a litigator who really likes going to court and is not going to encourage you to settle outside of court.
I was thinking, no, it's good, because I was just thinking about my own experience as a lawyer. I was never a litigator, but the way we were taught, right, in law school, with the rules of civil procedure, whatever. Once you're in that process, it's almost like you have these blinders.
Yes, that's exactly.
You can't see outside of it. You can't see outside of it. So you're so always fretting about the next deadline. You're always fretting about the binding of the documents, about all these stupid rules, right, that you have to follow, that you spend all your energy focused on these, making sure that your clients' documents, have a standard to meet and things like that. All these things, that a litigator has to worry about, that they don't have time to even think about the possibilities outside of the litigation world. And I didn't know about mediation really until my lawsuit was over. And I was like, gee, I wish I knew about that, and I didn't know there were options, which is the reason why I'm here doing these videos. It's because I absolutely agree with you, Laura, what you just said. It's just that it's kind of strange, paradoxical. You talk with your lawyer, and in our world, Eva, you say we instruct the lawyer to do things. It's almost like, what? You mean me as the client, I have to know more? I have to know more than what's out there for the lawyer, because the litigator, not that they're bad people, not that they're greedy, or not that they're ambitious, just the litigation. It's just that the training of a litigator is such a they just, all they know is litigation, and they don't think to even hey, you guys, how about trying mediation? How about trying med arb? Like, it wouldn't even come to them to even say that, to offer you. So whoever is watching this video now, you should be very happy that we're telling you, because there are options. You don't have to. I mean, even if you were able to settle, let's say you have 10 issues going on, right? And if you use mediation, or even just negotiation with your lawyers, just settle out as many issues as possible. You're saving yourself time, you're saving yourself money. And so by the time you do get to arbitration or trial, whatever you guys pick, then you just have those few issues, and then it's such a more streamlined process. But that all hinges on whether you know yourself to say to your litigator, hey, wait a second. Do we really have to go to trial with these 10 issues? You have to know it to even say to the litigator. Your litigator is just so busy.
Right.
Worrying about your deadlines. But yeah, so I think that's a great point, and that you're right, Laura. That is the great takeaway of this video. It's just that we really almost like the whole essence of these videos that we do here. It's so that we have this information for you to empower you to ask the right questions. I think to the lawyers.
Of your lawyer, yes, in whatever space you are, and going back to what you had mentioned, that you could be frustrated and overwhelmed and thinking, oh my God, do I have to know more? You don't have to necessarily know more than your lawyer. You won't know more than your lawyer, but you have to know better. You have to know better about yourself and what do you want out of this process, and you have to be able to elicit that information. You have to be able to share that information with your lawyer. As long as your lawyer relationship with you feels like a partnership, you're in a good relationship. If it feels dictatorialship and one direction, then you may want to consider someone who is actually hearing what you want, which is, I want a collaborative space, or I want the least amount of resources depleted on this in terms of time and emotional cost, right? So you should be at the very least able to share these needs to your lawyer and feel heard. And if somebody is dragging you in the litigation, then you may want to reconsider that, your needs are not really actually being heard if that's not the path you want to take. And if somebody is actually sharing with you what you're saying, Heather, these are the issues, and informs you about the issues at the table that are relevant to your case and can share with you, we can resolve this in collaboration, or we can try negotiation. This definitely will have to go to litigation. Well, then you're on a good path with your lawyer in terms of partnering with that. So they are hearing you, they are relaying information, they're describing to you what could not be negotiated, and then you make a decision based on that information, right? I mean, the last thing I'm going to say about this is that when families get served or they get trapped into this heavy machinery that I like to call the legal system, they feel that going to mediation, they lose options, or they lose their legal rights. But in fact, going to mediation, you're gaining options. You're not losing your legal rights. You just gain more options with those legal rights protected, which I think that's the understanding that families or individuals who are contemplating, or they are trapped, or they're about to go to litigation, is they don't have to feel that going through the litigation process is the only process that is going to protect their legal rights, because that is not the case.
Well said. Eva, do you have any last comments to add?
Sure. I think, one thing to take away is interview lawyers. You can do that. Interview lawyers, speak to more than one, and that can be one of your litmus tests when you're interviewing them in your consultation. Hey, what can you do for me to settle this out of court? And if you're finding that the lawyer's, really discouraging you from settling out of court and really pushing a litigation heavy response, you may review that as someone that doesn't align with your goals, right?
I think it's very interesting when you talk to different lawyers, because I remember I had that experience. I talked to several lawyers about our own case, and it's like they all have completely different answers to the one question. It's just really bizarre, I mean, because you always think that in law with logic and reasoning, if you have an issue, it leads to one answer. But when you talk to every lawyer has a different answer, and you're like, what? But yeah, no, that is a great point. So I think I'm going to end here now, unless anybody has any more to add. And we are going to be back next year, right, guys? So with lots more information for everyone. So don't forget to hit the subscribe and stay tuned for our next video. Thanks for watching, everyone, and